So before I really get deep into this, I'll just tell a little story. A long time ago, when I first got out of law school, I went to work at a big law firm in Boston, and my first job was to go into a conference room that was full of bankers' boxes. You know, it was just like what you would see on TV. It was just the bankers' boxes up to the roof. And this guy, who was a few years older than me anyway at the time, gave me terrible advice, but it stuck with me ever since. He said, you know, there's really only two things you can do to screw up your career. One is commingle client funds, but don't worry about that. You're never going to see a client fund for a long time. And the other is to produce a privileged document that's in one of these boxes. And so I have, I think, there's some variation of that fear of producing a privileged document that I think, you know, courses through all of our veins, that we think, oh my God, I just sent out a box of documents and that includes the one memo with, you know, the advice or whatever. So it keeps people up at night. It's something that, you know, it's just our instinct is to guard that very jealously. So when you get a claims file and every third entry is arguably a privileged entry, it is an anxious time. So the production of a claims file is I think one of those things that you know, you really have to. It forces you to really make very difficult decisions very early in the case. You have to decide what is privileged, and once you decide what's privileged, you have to really decide what do you want to try to fight about? What do you want to protect? So again, I'm going to refer to the Rhodes case, but it might just make sense really quickly to say the 4 or 5 things the Rhodes case says. And there's a lot of nuance to this, but what it says is the attorney-client privilege in a claims file will be honored. You don't have to produce attorney-client privilege stuff. The common interest, the tripartite relationship, but also relationship among lawyers and co-defendants, that does not spoil the privilege. A lawyer doesn't waive the privilege by talking to a lawyer for another defendant. That's also fine. And then you get into work product, which gets more difficult. So on work product, there are really 2 pieces to it. Rhodes makes a distinction about what is done in anticipation of litigation, and then the decision distinguishes between opinion work product and fact work product. In anticipation of litigation does not mean a fear of litigation. Every claim could end up in litigation. It's something much more concrete than that. And Judge Gantz doesn't say exactly what it is, but it's probably some sort of demand or certainly a lawsuit. But then so if an investigator is out taking witness statements before there's a 176D demand, that is not work product. Okay, that's a factual statement from a witness, for example. No protection for that. A factual statement for a witness that's taken after a 176D demand, that could be factual work product, but it's entitled to fairly low-level protection. Factual work product is not the same as opinion work product, and so in the Rhodes decision, the judge says if there is a need for that information, if the plaintiff can demonstrate a substantial need for that information, it'll be produced. And a substantial need in that case was really just to say, look, I can't get that information anywhere else. That gets us to opinion work product, which is the toughest of all. So after the 176D demand comes in, a claims person is making judgments about the claim, what to do about an investigation, what steps to make with respect to settlement, and oftentimes that's informed perhaps by legal advice. The judge says in that case, if there's a substantial need for it, it gets produced. There has to be a showing of a substantial need. And the same is true of reserves. Reserves could be protected work product, but if there's a showing of substantial need, they'll be produced. And I think that decision makes it pretty clear that in most cases, it is critical to get the thinking of the people who were making settlement decisions and investigation decisions. So it's a fairly low bar to get the reserve stuff and to get the opinion work product. Again, I'm not talking about attorney-client communications. I'm talking about work product. So anyway, that's Rhodes. You have to really think through the whole claims file as you do that. But I'm going to stick for a moment with the really hard decision, the really difficult one, which is the attorney-client privilege in a resolved third-party claim. So let's imagine that the claimant we talked about before sues the policyholder for a construction accident. Okay, and it's a very serious injury. The best offer before trial was $1 million, and that claimant received a $3 million jury verdict. The verdict is paid off, and now it's time to bring the 176D case. And so the question on everybody's mind is, what was the insurance company thinking when they made that $1 million offer? And so in a typical case, there might be cases, by the way, I'm not saying that insurance companies have never tried to lowball somebody, but usually that's a judgment call that was made. And usually it was made because the claims person said to the defense lawyer, what's this case worth? And the defense lawyer said, I don't know, but it's probably a range between $500,000 and $1.5 million. So the claims adjuster split the difference, offered $1 million, and they got a surprise at trial. Okay? So that opinion, that assessment that defense lawyer provided to you that says the case is worth $500,000 to $1.5 million is privileged. Do you produce it or not? Now, what are you going to say? How are you going to defend yourself if you don't produce it? It's a tough job. So it's a tough call. There's a lot of nuance to this. But that is the single most important decision you're going to make in a big dollar 176D case, is what to do about that. Now, it's never as simple as the one letter, though, because if you produce the one letter, the horse is out of the barn, and it's all coming in. All that lawyer's advice about the claim is likely to come into the case, okay? Good, bad, and otherwise. And so it's a tough call. You have to understand how exactly the claims file reflects that information from the lawyer. You have to understand whether there's stuff that didn't get into the claims file because the lawyer might be deposed and said, I picked up the phone and said, look, even though my report assesses this at $500,000 to $1.5 million, something's changed and I want to tell you about it. You have to know those things. So I'm probably stating the obvious here, but the question of privilege has to be so carefully thought through, and a lot of times plaintiffs are expecting that claims file, and you heard Marty say it, and I've been on the other side of this. It's not very hard to produce this. Well, it is pretty hard to produce it, because there's a lot of questions that you have to make, and you have to make it mindful of the fact that you can't selectively waive the attorney-client privilege. Okay, now doesn't mean if you produce a privileged document or privileged assessment of a case consciously, there's not a blanket waiver of everything that lawyer did or every lawyer did. But there is, generally speaking, a subject matter waiver, so that lawyer's advice about the claim is all going to be discoverable. Okay, and that's messy. It's very messy. But it's a hard decision, and it might be so messy that you decide, I'm just going to assert the privilege. It's my right. It's my client's right. I'm going to assert the privilege, and we'll defend the case on the claims person's otherwise objective assessments of the case. But anyway, I'm just pointing out, I suppose, the obvious point here. In a first-party case, okay, a case, let's say a policyholder is upset with the way you handled the claim because, let's just say, either the policyholder did not want the insurance company to settle. Maybe it's a loss-sensitive premium program. So the policyholder says, look, I don't think that's a $3 million case. I don't want you to settle it. Go to trial. I want you to see if we can do better. okay? But the insurance company settles it anyway because it has an obligation, and under their policy, the duty and the right to settle. The policyholder's upset and says, look, you just settled that. It's going to badly affect my loss runs. It's going to jack up my premium. They sue you for, the policyholder sues for that, okay? Very different issue there because the privilege belongs to the policyholder and to the carrier, and you just have to sort it out with the policyholder there. But probably in that kind of case, all that stuff's going to come in because you're both fighting about the same advice, right? You're both trying to say what the claim was reasonably worth and what was motivating the settlement. But in any event, my overarching theme on privilege is it is a minefield, and you have to really think carefully, really from the day you look at that claims file. Who are the lawyers? A lot of times claims people will have entries in there that really are just cut and paste from a lawyer's email, for example. So you have to figure that out too. So,
awesome.
So, Dan, I have a question for you. My experience has been that insurers hate to make the decision to decide to go with reliance on advice of counsel because they know about the privilege waiver involved. You, I think, in some of these materials have said that that's a decision that should be made early on.
Right.
In my cases, I've gotten all the way past, summary judgment and heading toward close to trial, and they still won't make that call. And I think sometimes what's motivating them is maybe discovery will close and they won't get to depose the lawyer. But how do you balance that sort of, this is an apocalyptic decision potentially to make, and your good advice that you should make it early on?
well, let's say you're the insurance company in that situation, and you decide after discovery closes you're going to waive the privilege. I can't imagine you could try the case and get away with that. I mean, it's the worst of all worlds. You would waive the privilege and not be able to use it at trial. Or at least that's the risk, right? Is the judge would say, I'm not going to let you now
Hopefully.
put in a lawyer's advice, and when it's too late to take any discovery on the lawyer's advice. So I mean, every case is different, and again, I want to make very clear, I'm not a coverage lawyer, so I don't know that world all that well, Marty, but I think that's a very risky thing for insurance company to make, for any litigant, to make such a dramatic change at the 11th hour, because I think the risk is you give them all the privilege stuff, so you get all the downside, but you don't get any upside from that.
Awesome. Thanks, fellas. Okay. We're now going to channel the judge just a little bit. So as Dan really accurately described, when you read Rhodes and you look at the cases, there's kind of a hierarchy, right? There's the attorney-client privilege is going to get pretty solid protection unless the insurer consciously waives it. And then you've got work product, which you've got fact work product, which will get much less protection. You've got opinion work product, which will get much more protection depending upon who it is, because the claims rep generally gets less protection. And then you've got this sort of Rubicon that you cross once litigation is threatened or commenced, where the protections ratchet up. Again, the privileges become more enforced than prior to that moment. And so the first hypothetical that I put out there for the judge was probably not a great one, but he still managed to spin it around and make it interesting. And so I asked him if claimant's counsel alleges bad faith in an initial demand letter while the insurer is still investigating the claim, do subsequent consultations with counsel become privileged? I'd say the answer is probably yes. But he made it interesting because he focused on what Marty was talking about, and that's the role of the lawyer. And so the interesting thing, I think, is that the court is very much aware of that potential, and he says the attorney-client privilege protects legal advice but not business advice, and I'm now reading the judge's comments. The outcome of this hypothetical would turn primarily on the kind of advice being provided by analysis/consulting counsel. The court is aware that things aren't always what they seem or what they purport to be. For example, outside attorneys sometimes act as third-party administrators. This is a good place to note the Rhodes versus AIG case and its useful guidance. So the court is attuned to the idea that an attorney isn't necessarily always functioning as an attorney issuing legal advice. So Judge Davis did a wonderful job taking my pitiful hypothetical and making it interesting in that case. Now, the next hypothetical, actually, I like a lot better. And this one is based on something that I actually do all the time. As an aside, I think that plaintiffs' lawyers sling the 176D allegation way too early and way too often. You know, it just seems to pop out of their mouths almost from the get-go, and I think that's a terrible idea. I think you actually should, for a very long suffering period of time, try to persuade the insurer that your claim is valid and that they should pay you. And you should give them all the information to let them make that decision, and you should play nice with them and give them the opportunity to either do the right thing or to hang themselves by doing the wrong thing in the face of a long-suffering claimant that keeps giving them what they need to make the right decision. And so I think you really should not shout 176D until you're pretty far down the path. And that's particularly true in light of this discovery issue, right? Because once you threaten litigation, then they're going to get to assert more privilege, more work product protection than they do before you threaten litigation. And so one thing I do a lot is in my letters, I won't threaten litigation, but I'll use the language right out of the statute so they know perfectly well what I'm talking about, but I'm not actually threatening them. I'm just saying that liability is reasonably clear and they now have a duty to settle the case. You know, no big deal. But they know what I'm saying. And so I asked the judge, you know, does that count? If I send the insurer a letter and I say that liability is reasonably clear and the insurer now owes me a duty to make a prompt, fair, and equitable settlement offer, which comes right out of the statute, have I now threatened litigation in a way that lets them now ratchet up the level of protection that they have for their work product? And his comment was probably not. Rhodes says that the work product protection kicks in for the insurer when litigation has been threatened or commenced. Simply reminding the insurer of its obligation to settle a claim promptly after liability has become reasonably clear is not the same as threatening or commencing litigation or its functional equivalent. Not every case results in threatened or actual litigation, also noted in Rhodes. So an implicit threat of litigation likely would not be enough to invoke the protections of the work product doctrine. And I again hasten to add his disclaimer that this is just his thoughts, one judge out of 82. But I was quite pleased to hear that. The other thing that I just want to highlight for all of you is that Judge Davis gave us some really interesting decisions in the materials that kind of follow up on the Rhodes concept. He's got the Shigemoto decision, which deals with the application of the work product doctrine to witness statements, and the Minkaina decision. I don't know if I'm saying those right, but both deserve some attention. And I think the point that he's making there is that even after litigation is threatened or commenced, and the work product doctrine protection is elevated, if you will, there's still this sort of backdoor substantial need concept, which is in Rule 26, B3, where even when there is work product protection, you can still show substantial need and undue hardship without them, and you can still get access to some work product materials that might otherwise be protected because litigation has been threatened or commenced. And I asked him what the primary considerations were driving a determination of substantial need or undue hardship, and his comment was, this is a very fact-driven analysis. It turns in large part on what the claimant is reasonably entitled to know, has to demonstrate a substantial need. Where else, if anywhere, can the claimant get the information or its substantial equivalent? And what hardship would be involved for the claimant to obtain the information from that alternative source? I can't predict the outcome in every case, but counsel should be aware that a backdoor to the work product doctrine exists.
So, Judge Davis, I have a question for you. It seems to me, having read Rhodes, that the bottom line is that in any one of these cases where you have a claimant plaintiff contending that the case was not settled for a reasonable amount when liability became reasonably clear, I'm going to be able to show substantial need, and I'm going to be able to show that I can't get the stuff elsewhere, because how in the world else can I prove the state of mind of the insurer than by getting their claim file? I don't even care whether it was before or after when, when litigation became imminent. I'm going to get it. Isn't that what Rhodes says?
Well, you're preaching to the plaintiff's choir on that one. I think you are. I mean, at least with regard to the claims rep, right? Because I think there's also a hierarchy within Rhodes about who you're talking about. And so I think if I'm reading it right, if you are looking for even the opinion work product of the claims rep, of the person who made the decision, to settle, not settle, cover, not cover, I think you're going to get that. Other people, maybe not so much. If the claims rep was relying on a forensic accountant, and the forensic accountant told the claims rep, I don't know, only offer them $100,000 or something, I think you're going to have a harder time getting to the opinion work product of the accountant, if I'm reading Rhodes right, than the claims rep. I don't think it's out of the question, but I still think there's a hierarchy.
Yeah, I agree with that. The subtext of Rhodes, I think, is that Judge Gantz is skeptical of any work product privilege that's being asserted by anyone other than a lawyer. I mean, if you read it, he's protective of information that you can actually trace to a lawyer giving to the client, and in that case, everything else is produced.
Okay, it's perilously close to 5:30. Sort of my fault because I'm supposed to be the moderator, but I really was enjoying hearing what Marty and Dan had to say. So, but I'm going to, I guess, use the moderator's fiat here, and we're going to jump to advice of counsel, which I think follows from what we've been talking about and is perhaps the next most important of our topics. I originally put it last, but we can buzz through some of the other stuff quickly at the end if we have time. But I don't want to miss out on hearing what the panel thinks about advice of counsel. So, okay. So, Marty.
Well, I think I'll rest. The conversation that Dan and I had toward the end of Dan's last piece was all about the advice of counsel issue. I've said that you want to try to draw out as soon as possible whether that is going to be invoked, whether the insurer is going to defend its decisions either with respect to settlement or with respect to coverage by saying, hey, my lawyer told me so, as early as you can, and then go after it, and as Dan's comments suggested, argue for as broad a subject matter waiver as you can get based on that, and then pursue all of it, and almost inevitably there are going to be warts. So from the policyholder's perspective, love to hear that, and let's go after it, and usually it's not going to be completely clean at the end of the day, but I think otherwise our conversation at the end of Dan's presentation was really into this issue.
Yeah, and I kind of talked a lot about this in the privilege piece as well, but let me just make something else clear. I think you may all know this, but the advice of counsel defense, in some contexts, a very specific defense. If you've ever done any securities work, for example, it's somebody trades on insider information and they say, hey, I told the company's lawyer I was aware of the earnings coming out in 2 months. He cleared the trade. It's a very specific defense, the advice of counsel. In this context, that's not really what we're talking about. What we're talking about is, from the insurance company's perspective, any information from a lawyer, otherwise privileged, that just tends to show good faith or disprove bad faith, however you look at it. So it might be as simple as a defense lawyer. I mean, I used before the dramatic example of the lawyer saying, this case is just worth $500,000, that's good evidence to support your $1 million settlement offer. It's very good evidence of that, right? But it's more than that. It might be that that 2 months earlier, that the defense lawyer sent a memo and said, "Hey, we just took the deposition of the crane operator, and it turns out that he was a terrible witness. He came across as somebody that was careless, or whatever the report is, loaded with subjective judgments that you want to make." Well, that is privileged, but it's the kind of thing again that it's part of the hard decision we talked about before, which is whether you want to put it into evidence or not. Now, the real hard thing to figure out, and God bless you if you know how to do this, but the real hard thing to figure out in advance is, did the claims person follow the advice, right? Because that's the worst thing of all, is you produce the lawyer's advice, and then you have a claims person who didn't attend the depositions, who's never tried a case, who's going to sit there and say, "Yeah, he told me it was worth $1 million, but I thought it was $500,000. And yeah, he said it was the crane operator was a terrible witness. I thought the crane operator was a good witness. I didn't go to the deposition, but that's what I thought." So, that's the hard part about the advice of counsel. It's never going to be, as Marty said, it's never going to be crystal clear. But it's in a 176D case. It's, I think, the hardest decision there is whether or not you're going to assert the privilege and try to make your case without referring to the lawyer, or are you going to count on the lawyer to stand by the advice and the claims person to talk about how the claims person considered that advice as they were making their settlement judgments.
One other thing I would sorry about that, it's twice, is just that for purposes of preventing an insurer from making the decision to rely on advice of counsel very late in the game, it's a great idea during the examination in deposition of the claim representative to put the questions about what the advice of counsel was, get the objections and the instructions not to answer on the record, so that when it comes time for trial, you have a motion in limine in which you can say nothing in the way of advice of counsel can be offered by the insurer in support of their decision because of the position that they have taken that is protected.
And I've been on both sides of this issue, but when I'm pursuing an insurance company, I'll just ask an interrogatory early on: are you relying on the advice of counsel to prove good faith or disprove bad faith in any way? And if so, blah, blah, blah. Who's the lawyer, what they say, when they say it?
Right. I guess my addition to that would be, I'm most interested in those instances where the insurer does not assert advice of counsel. And then I still want to know, did you talk to a lawyer? Who'd you talk to? When did you talk to him? What'd you ask him? What did he say? Did you talk to more than one lawyer, right? Because maybe if they went to a second one, they didn't like the advice of the first one, they went to another one. And so I'm going to ask all of those questions, and I'm going to try to get an adverse inference, right? Because in a civil case, if someone asserts the privilege, you get an adverse inference. So I say, if you consulted your lawyer back in September 2014 and you're not asserting advice of counsel, well, I know pretty well he gave you advice you don't want me to hear. And so
I'm not sure about that legal proposition.
Yeah, I guess I'm not either. Yeah. Is that established by some case?
Well, there's definitely cases that say you can get an adverse inference. I can't claim I've ever pulled it off at a trial.
What circumstances are necessary to justify the adverse inference? That's the only thing I'm just not sure about.
I think if it's a topic that you would expect the advice to come in on, and they assert a privilege and assert the attorney-client privilege, I think you get it. But I think that's why you've got to ask, 20 questions at the deposition to try to find one that you're going to get to tag them with. You can't just say, did you consult a lawyer? Yes, and you're not asserting advice of counsel. That's not going to do it. I would put them through the paces at the deposition and say, did they advise you on this? Did they advise you on that? And so, again, I've never actually pulled this off at a trial. But I'm always gunning for it. So, I think it's a worthy endeavor, and I think it's plausible, right? Because they're only going to assert advice of counsel if the advice of counsel is good for them. And so when they don't do it, that's when I think it's the most interesting. And maybe even if you don't get maybe if the court doesn't give you an adverse inference instruction, at least you can insinuate it to the jury, right? So they consulted their lawyer in September, and we didn't hear from the lawyer, did we? And they didn't assert advice of counsel. I say you can argue it. So
You'd have a fight on that one, Sean.
Even from me.
I'm used to that. All right. Why don't we back up? Let's see, 538. What's the next most interesting? Underwriting file? No?
It won't take long to cover the underwriting file, so I think we should.
Okay.
And the underwriting file, again, tends to be relevant or not, depending in large part on the kind of case you're handling. And the kinds of cases that I handle, where there is always a coverage issue that's being debated, it will often be relevant. The underwriting process is not just one of purchasing a policy and paying a premium, and even not just one of making the disclosures necessary so that the insurer can judge whether they want to underwrite the risk, and if so, at what premium. But it is also the negotiation of the policy. And from time to time, there's real substantive negotiation. Some of us just, some folks will just have clients who bought the policy off the shelf without a single change to it. But actually, most insurance policies are festooned with a dozen or 2 or 3 dozen endorsements changing the policy, some of which may be forms themselves, but others of which may be manuscripted. There may have been options as to which of several forms would be used in your client's case. And sometimes that can bear pretty substantially on the question of whether the insurer, now denying a claim, is doing so in good faith based on what that negotiation history shows. So I'll give an example from a case I've referred to before, this case involving the contaminated food. Well, a big issue in that case is who made the judgment as to how to handle the damaged merchandise after the damage. And there was a clause that spoke very specifically to that. And this clause was supremely favorable to the policyholder. And yet, the insurer was trying to argue it as if it wasn't, as if it was closer to the norm. Well, we got the underwriting file, and lo and behold, what did we find? That there was a negotiation in which the policyholder was asked to accept a more stringent form of clause concerning who has the authority over the property after it's been damaged. That was very much like the argument that the insurer was giving in the litigation to say that there was no coverage, but the policyholder said no, and they got this incredibly broad provision which said it's 100% your call what you do with this stuff, and if you think that the only reasonable thing to do with it is to destroy it, you go ahead and destroy it. And yet now they're arguing that they got the clause they didn't get. That is highly relevant to a bad faith in my kind of case, where the argument would be that the insurer is much more focused on their own bottom line and not wanting to pay this claim than they are on doing the right thing under their policy. So from where I stand, it can be highly relevant. And it can also be relevant in the claim handling part of it, because sometimes it can be really kind of funny to see situations where insurers do not have any communication between their claims and underwriting sides. And it is because they have a policy. You are not to call the underwriter if you're handling a claim. But that isn't always the case. And sometimes they will have an exchange. And sometimes what the underwriter tells the claim handler is not entirely consistent with what the claim handler would like to assert in denying the claim. And so that's another reason why you want to get the underwriting file, because it may not have stopped at underwriting. The underwriters, although they put their papers in the same place, may have become involved in the handling of the claim.
Yeah, so I would just say a couple things. First of all, an underwriting file, of course, is going to vary depending on what kind of policy, what kind of account you're talking about. But let's assume we're talking about a fairly large commercial account. I mean, there's a lot in there. So it's going to be typically loss history that shows all of this company's losses from all of its plants or locations. It's going to have credit history that shows the financial information, creditworthiness of the policyholder. Are they going to be able to pay us their high deductible, whatever? And then there may be some negotiations back and forth about, well, the premium's too high. What if we don't insure these locations? What if we carve out this part of our business and put that into a different program or whatever? All of that then, at least if it works well, is reduced to a contract, insurance policy. So if it's a first party claim, a policyholder claim, my first question would be, how is that relevant? I mean, you have a written contract that says what your rights are and what our obligations are. If we went back and forth for 6 months about what it was going to cost or how we're going to shape this, how is that going to inform anything? Now, I take Marty's point that if there's an ambiguous provision, if there's, I've seen it in the context of fight over how you're going to calculate the premium. We said we were going to take payroll times 2.1. Oh, I thought that was going to be payroll minus the Western Mass project, whatever. Okay, then it's specific, in which case I would say you'll get that specific part of the underwriting file, but not the whole underwriting file. As it relates to a third-party claim, I'm sure there are instances where it might be relevant, but I can't think of them. I can't think of any time when a third party is suing an insurance company for mishandling a claim that you would ever produce the underwriting file. I just, I'm sure there are situations out there, but I just can't think of them. It's dense, sensitive information, and I would really fight hard not to produce it.
On this one, the hypothetical that I posed to the judge was in an instance where the insurer denies the claim based on a policy exclusion that the insured claims is ambiguous and the insurer argues is not. Insured asserts that it specifically discussed the risk with the underwriter and was assured this risk was covered. The judge responded, on the limited facts presented, at least that portion of the underwriting file which discloses communications between the underwriter and the insured prior to the issuance of the policy likely would be deemed discoverable. And frankly, when you look at the cases, that's kind of where you see the courts open to letting you get at the underwriting file. It's sort of contract offenses where there's a fight about a clause or sometimes affirmative defenses, but it's all coverage stuff, as Dan says. I don't think I've ever seen even a case in a third-party context where the underwriting file came in. I suppose if the insurer was defending on a coverage basis that the policyholder had made a misrep in the policy, and so therefore I'm not going to cover or something like that maybe. But you'd have to be kind of 2 steps down the path, I think. In the third-party context. Yeah. All right. Do we have time for one more, or should we go straight to questions? What does the group think? Do you want to go straight to questions, or do you want to hear about similar claims or claims manuals? Or reserves? All right, let's jump to reserves.
What Judge Gantz has said, once again, in the Rhodes case, I think if we just demonstrated nothing else to you folks today, it's that the Rhodes case is must read, is that they generally are relevant in a case in which the question is whether the insurer breached its duty to settle a case in which liability was reasonably clear for a reasonable amount, because that's exactly what the reserve does, is it expresses the insurer's judgment as to the likely outcome as best they can predict it. So if they've got a reserve of $10 million and they're offering $50,000, they're lowballing. I think Judge Gantz's opinion is pretty clear on that. unless there's, and I don't know of any authority to the contrary since he wrote that in 2006. The other question would be whether reserves are relevant in the context of what's been referred to here today as the first party, the policyholder versus insurer coverage case as opposed to the tort case. And insofar as an insurer may properly set a reserve that is discounted by the insurer's judgment as to the likelihood of whether or not the coverage would apply, as distinguished from the value of the underlying case, distinct from coverage, then I think it could also be relevant in that it would perhaps show, if it is a very high reserve, where the insurer is now saying, of course there's no coverage, that the insurer doesn't really have the confidence that it is trying to project with regard to its coverage position.
Yeah, I agree with that. I'm going to circle back a little bit to something Sean said earlier, which is he thinks that plaintiff's counsel fire the 176D bullet a little bit too early many times, and I agree with that. I think it's over. It's just over. It's overused. But one consequence of making that 176D claim early is oftentimes you get a new set of eyes on the claims file. And, I don't think I'm giving anything away here when I say one of the first things people do is they look at the reserves, they look at the settlement offer, and all of a sudden they're going to start to match up. They should, anyway, they should. And I don't mean dollar for dollar, but within a range. And, I think that's wise advice to give to your clients because, as Marty says, in a 176D case, it all gets to these sort of subjective things about what was a reasonable range. And, people talk about claims, generally speaking, oh, it's a strong claim, it's a weak claim, I thought we had a good shot or bad shot. A reserve is it's just so specific. At a point in time, I told my boss that I thought this was $1 million claim. That's pretty powerful evidence. So I think that there are arguments for why it wouldn't be disclosed. I think they're losers for the most part. And there's some authority, and there's some instances when it wouldn't get discovered. But I think by and large, the reserves are going to come out.
I guess the thoughts that I would add is that when you look, I guess outside of Massachusetts in particular, there's all sorts of cases out there that say that the reserves don't get discovered, right, because they're of marginal relevance, allegedly. And so I did find an interesting case that suggests that what really distinguishes the discoverable reserves from the non-discoverable reserves is figuring out what goes into the insurance company's process in setting the reserves. And so you should really be poking at what their policies and procedures are. How did you set this reserve? What went into it? And trying to ask those questions to set up the idea that this really is an indication of how they valued the claim. And therefore, if they offered me $50,000 when the reserve was $1 million, that really does matter. And it wasn't just some, CYA number that they threw out there just in case the sky collapsed. And so asking those sort of predicate questions to set up the idea that you're going to get at the reserves can be important if you end up in that kind of battle.
That's an important point, too, because there's no real uniform, at least in my experience, uniform approach to reserves. Different carriers have different definitions, different claims people have different sort of instincts and motivations and how they set it. A lot of times a policyholder is putting pressure on the claims person to keep the reserves down. They have to fight back against that. So there's a lot to be said about reserves, and it could be that they're not admissible for that reason, but I think by and large they're discoverable.
All right. We're skipping a couple of small topics, but we are into the question zone, so have we generated any questions?
Hi. When it comes to the privilege impact, what would be the consequence if a policyholder assigns his claim against his insurance company for contract 93A to the third-party claimant, either voluntarily or maybe involuntarily by way of judicial assignment, would that create adversity between the policyholder and the insurer, such that any communications between the policyholder's insurance defense counsel and the insurer might be discoverable by the third-party claimant?
I think there'd be a pretty hard and fast dividing line. Anything that happened before that, I would think that the privilege would apply just as it always did. Any communications after that, they obviously are no longer sharing any kind of common interest, and so those would not be protected.
Right, just to pick up the thought, I mean, I think that stems from that sort of idea that both parties have to waive the common interest in order to pierce it, so the fact that you assign it, I don't think would be the equivalent of waiving. I think the insurance company would still have the privilege prior to the assignment, so I would agree with Marty.
Yeah, I got a question. This is a two-part question. First of all, if first-party case, if an insurance company alleges that they made a fair offer on a claim, tort claim, but they do not respond to a request for arbitration, first-party claim, my first part of the question is that a violation, a contractual violation, first of all, which arises to 176D? And the second part is there attorney's fees involved that if the court deems to be there was a reasonable offer, but just the insured does not want to accept that offer and he wants to arbitrate that?
Do you mean arbitration or mediation?
It's a claim. It's arbitration.
Oh, it's an auto claim.
First-party claim. So the issue is that a violation if they made an offer but they just don't respond to arbitration and the insured requests continuously, I want to arbitrate the case, I'm not happy with your offer, and they have a contractual obligation to arbitrate the case. Now, if he wins and he wins the same amount or maybe more in arbitration, is he still entitled to attorney's fees for failure to arbitrate on a timely basis?
I don't know.
I guess I don't know either.
Are you talking about an appraisal process under a property policy?
No. This is a bodily injury claim.
Okay, so it's auto.
Yes,
Auto.
I don't know.
Yeah, I don't do auto, so I don't have that for you.
Well, the concept is similar. If they offer you a certain amount of money, you refuse to take it, you're the insured, your first-party claim, you say, look, I want to arbitrate the case pursuant to the policy, and they just stay silent in respect to that request for arbitration, then you go arbitrate the case, and then you get the same amount or even more, but are you entitled to attorney's fees because they just refuse to abide by their contractual obligations?
Yeah, I think you could still have a 93A claim. Your principal damages would be the time value of money problem. Not sure it could be more than that, but then you'd have to read the other Rhodes case, the maybe more famous one from the SJC. And so I think you could have a 93A claim in that circumstance. And if you have a 93A claim, then your attorney's fees for successful pursuit of that 93A claim are recoverable.
Yeah, I mean, off the cuff, maybe this is under a subsection G, compelling you to institute litigation. And the argument would be roughly that the process that you've been forced to follow is more expensive than the arbitration procedure that they were obligated to pursue under the contract. But I think there's too many divergent outcomes there to give you a decent opinion off the cuff, really. So,
In a next question is in a coverage dispute for first-party coverage, if you've got a situation where counsel has been assigned to defend both the 93A and the coverage dispute, why, from a strategic point of view, have you declared that that you would wait to the deposition to seek an order from the court to have them turn over the privileged materials, the communications? Why wouldn't you do it in advance so that you'd get that resolved ahead of time and then go into the deposition of the claims rep in advance? So, and that is my second part of the question is, wouldn't it be advisable to have a separate attorney handle the coverage analysis for purposes of litigation and a second attorney handle the 93A 176D?
Well, I'll take a crack at it if I understand it right. So there's a first-party claim against the carrier for both a coverage determination and a 176D violation, right?
Correct, yeah.
So, and the basis of the 176D violation is what? That they're wrong about the coverage
Correct.
question?
There's a denial of coverage,
Yeah.
which is being contested.
So, so on the first question, or maybe it's the second question, should there be two separate lawyers there? I see those as the same claim, as I understand it. I mean, you're basically saying there's a contract breach and then a contract breach plus, like, you know, so in that case, you'd probably have to show they didn't just breach the contract, but it was, they did it without even reading the relevant information, a bad investigation, they didn't get a legal opinion that they should have had, something like that, right? So it's probably, one lawyer for both claims is probably makes sense because they're really the same claim. One's a little more than the other. That's what my guess. And then the question about the privilege, that's on a coverage case, it's a different thing than the sort of claims case. The third party case I was just talking about there. But, oftentimes in coverage cases, there is a separate lawyer that comes in and gives the carrier an opinion. In my opinion, this is covered or it is not covered. That lawyer has nothing else to do with the case. And then the insurance company can make a decision whether they want to rely on that or not. It's not as difficult a decision, I think, as it would be where you're ongoing getting information from defense counsel because it's a discrete question they ask. So I don't know if that helps, but.
Well, what I'm thinking of is in a situation where you've got the attorney that comes in later on to handle the case is also giving advice on the coverage matter and also giving advice on the bad faith exposure. So the argument from the insurer's point of view is, well, that's privileged. But they've asserted the advice of counsel situation, so you can't have it both ways. So if you get the claim rep on the stand or even the attorney on the stand, the attorney's going to have to be disqualified because he or she becomes a witness. So wouldn't it make more sense to have the attorney handle just the bad faith aspects and the other one handle purely just the contractual issues?
Yeah, it might.
But then that would waive the privilege if one attorney handled both aspects.
Well, the case law about the privilege is, it's all about fairness. You can't use the privilege as a sword and a shield. So you can't bludgeon someone with the privilege saying, look, I made a good decision, my lawyer told me this, and at the same time say, but you can't know what the lawyer did. So you got to pick one or the other. And then once you do, I think there are an infinite number of possibilities that flow from that, and I could imagine, I mean, I don't know your case, but I could imagine that it could lead to, if the lawyer giving the opinion is trial counsel, well, you can't try the case. So, yeah, that would be one of the consequences.
The other comment I would make on that one is that what will sometimes happen, and maybe it's for the wrong reasons, but because I think your idea is a good one, will sometimes happen is that as the case moves along, it'll become more and more evident that trial counsel is going to be the partner of the one who is giving the advice all along. And since I think in most jurisdictions in Massachusetts right now, the disqualification for one who would have to testify does not apply to the whole firm, that sort of solves their problem.
Yeah. And it also doesn't apply at all until trial. So a lawyer witness can defend the case, prosecute the case, they just can't try the case.
Thank you.
Do you have one? Yeah.
Is that to me?
Yeah.
Yeah, so whether to sever and stay is a really kind of fact dependent question, but if to get back to like the gentleman's question back there about a case where the 176D case and the contract case are really the same facts, I don't know that severing that kind of case makes a ton of sense, because you don't want to have two trials on the same issue. You're not worried about a claims file, it sounds like. But I think it's very fact.
I guess my comment would be that one of the things we didn't get to, partly because we didn't cover the other two subjects, is that a lot of this is economics. What makes sense in terms of the policyholder's investment in the coverage case? You know, as a coverage lawyer, I know I hate losing for sure, but almost as much, I hate being non-cost effective in apparent success. And so I might take a case where, yeah, I'm going to put in that bad faith claim, but I'm going to move for summary judgment just as soon as the court will let me. And if I prevail on that, then I'm in great shape to pursue the rest of the case. And it already has been bifurcated. I've won the coverage issue. Maybe I haven't had a determination of the damages flowing from it. So in that circumstance, I'm more than happy to have it separated. It's really a matter of how big a case it is, how much the client wants to spend on it, what really makes sense from an economic perspective.
I guess I would pick up on that theme, and I guess perhaps the cases that I'm doing, the stakes are somewhat lower, and so I'm rarely interested in a sever and stay, right? I want to do it all in one go. And also I think I always have a plausible assertion that I should get the 176D to go along with the coverage. You know, you could get admissions, you can find stuff in the claims file where they recognize that there should have been coverage, or where you can see them dancing trying to come up with a new reason to avoid coverage, and I think that's all good. So typically I don't want to sever and stay. And I've had pretty good luck having it not come up, I think, as I mentioned earlier. So far so good. I couldn't tell you, and as I mentioned earlier, when we looked through the materials, as Marty pointed out, the cases in the materials are all that third-party tort case, sever and stay. But I would say the reported decisions I've seen generally display some real enthusiasm for the sever and stay. So at least in the third-party context, as a plaintiff side, you're probably going to lose that. It's going to get severed and stay, more likely than not, unless you can come up with a really good reason, you know, not to. As I said, in the policyholder context, I've had better luck. Yeah.
Hi, I wanted to direct this to Marty. You've mentioned a couple times filing motion for summary judgment as quickly as possible. So if you succeed, does that embolden you going forward on the 176D 93A claim?
Well, sure, particularly if the theory is that the insurer had no plausible basis for the ground on which it disclaimed coverage, which is what you have to have in order for a sort of heighten things beyond just the contract case. So I know that I'm going to have to win on coverage if that's ever going to have any legs. I want to know the answer to that question without spending a ton of the client's money trying to prove that not only did you get it wrong, but you got it wrong without a plausible basis to do so.
Right.
So, have I answered the question?
Yeah, okay. Yeah. All right. Well, thank you all so much for coming. Hope you've enjoyed it, and thanks again.